Welcome to Court Briefs, a podcast from Paul Weiss. I'm your host, Kannon Shanmugam, the chair of the firm's Supreme Court and Appellate litigation practice, and co-chair of our litigation department. In this podcast, we analyze Supreme Court decisions of interest to the business community. Today, I'm coming to you from the British Commercial Bar Association conference in Stockholm, and I'm joined by my colleague, Will Marks, who's back in the office in Washington. And we're going to talk about the Supreme Court's recent decision in a case called Cantero versus Bank of America. This is a case involving the preemption of state law by federal law in the context of banking regulation. So, Will, tell us a little bit about the facts of this case.
Sure. So the plaintiffs in this case were customers of Bank of America, and they had taken out mortgages from the bank on homes in the state of New York. Like most mortgages, the bank required the customers to make monthly payments into escrow accounts in order to fund property tax payments and home insurance. Now, under New York law, the bank was required to pay a minimum of 2% interest on the balance in the escrow accounts. But the bank was not paying any interest, and it actually took the position and expressly informed its customers that it believed the New York law was preempted by the Federal National Bank Act.
So how did this case get to the Supreme Court?
So the plaintiffs filed suit in a federal court in New York, arguing that the bank was violating this New York law. And as you might expect, the bank responded that the law was preempted by the National Bank Act. The district court disagreed with the bank, but the Second Circuit ultimately reversed the district court's decision. The Second Circuit held that any state law that purports to exercise control over a federal national bank power was preempted. And in the Second Circuit's view, the New York law in question was attempting to control Bank of America's national federal power to create and fund escrow accounts. The Supreme Court ultimately granted review to determine whether the National Bank Act preempts these sorts of state escrow interest laws.
So in its early decisions so far this year, it seems like the Supreme Court has had a number of cases where it has reached unanimous decisions, but not really decided all that much. And it sure seems like this decision is the latest in that string. Is that fair, Will?
I think that's exactly right, Kannon. The Supreme Court really didn't do much in this decision. It held only that the Second Circuit had applied the wrong preemption standard, and the Supreme Court remanded for the Second Circuit to apply the correct preemption standard.
So, Will, perhaps we should stop here and explain to our listeners how preemption operates in this context. So when we're talking about preemption, we're talking about the displacement of state law by federal law. And the way that preemption operates under the National Bank Act is frankly unique. And so, Will, why don't we talk a little bit about how that works in this context?
Sure. So the National Bank Act is an older statute, and ordinarily you would think that courts would simply interpret the statute and determine whether it preempted state law. But here in 2008, Congress enacted a specific statutory preemption framework in the Dodd-Frank Act. Now, there are two forms of preemption articulated in the Dodd-Frank Act. The first one is that state law is preempted when it discriminates against a national bank. Now, there's no allegation of discrimination in this case, so that form of preemption wasn't present. But the second form of preemption is where state law prevents or significantly interferes with a national bank's exercise of its federally granted powers. And this is where the standard gets really unique and frankly, a bit unusual. To apply that standard, Congress actually dictated that courts should apply the standard that the Supreme Court applied in a 1996 case called Barnett Bank. So the statute not only sets forth a statutory preemption test, but it requires courts to effectively continue to follow a previous Supreme Court case.
So at the risk of a bad pun here, Will, how did the analysis cash out in this context?
Well, Barnett Bank didn't provide a clear test, and the Supreme Court again refused to apply a clear test. When the Supreme Court overviewed Barnett Bank, it interpreted the decision as essentially following a sort of common law approach to adjudication. Under that approach, the court essentially took the state law before it and compared it to the state laws at issue in previous cases, some of which held that a state law was preempted, some of which held that a state law was not preempted. And the court in Barnett Bank essentially did a comparative analysis to determine which side of the line the state law before it fell. The Supreme Court held in Cantero that this exact form of common law analysis is essentially what Congress had codified in Dodd-Frank. So the court, again, didn't provide a clear rule, but it said that the Second Circuit had failed to engage in this sort of comparative analysis. And because of that problem, the Supreme Court vacated the Second Circuit's decision and remanded for the Second Circuit to apply the correct test.
So given that the Supreme Court didn't even reach a definitive result about the New York law at issue, what are the takeaways from this decision?
Well, I think the big takeaway is that preemption in this context is inherently fact-specific, and now that Congress has codified Barnett Bank, it essentially will always be fact-specific. And something that banks will have to take into account is that there's always going to be inherent litigation risk and inherent risk that a court will disagree with a bank's preemption determination if a bank affirmatively takes a position that it does not have to comply with a state law because the National Bank Act preempts it.
Great. Well, thank you, Will, for breaking down this decision. And if you have any questions about the decision, please feel free to reach out either to Will or to me. For more information about Paul Weiss's Supreme Court and appellate litigation practice, please visit us at our website, paulweiss.com. And please subscribe to Court Briefs wherever you listen to your podcasts. Until next time, thank you for joining us and take care.